Hi, my name is Akiva Goldman, and I'm an attorney with Goldman and Associates, and today we're going to continue our videos about interesting topics in family law. Please subscribe, and you'll get full access to all the information that we provide. This is a very interesting topic. It's a question that one of our regular subscribers asked that we do a video on, and that is, can my ex take a piece of my inheritance if we get divorced? Well, here's the interesting thing. The question really is, what is defined when you say, my inheritance? If you get an inheritance, let's say you get a $100,000 inheritance. A parent passed away, you got it. If you take that inheritance, put it in a separate account called my inheritance, for example, or you otherwise keep it separate, and you never commingle it with marital assets, then it's literally your inheritance, and your ex, as a general proposition, if there's a divorce, cannot take your inheritance. Now, I'll get to a proviso about that later, but let me continue with this thought. If you take your inheritance and you commingle it with the marital asset, like you put it in the joint account with your husband or wife, then you've changed it. It's no longer your inheritance. It has become a gift to the marriage. It's a marital asset. It's in play when you get divorced. So you've taken your inheritance and dissolved it. You've dissolved it and transformed it into something else. So now when you're getting divorced, you can't say, well, that's my inheritance. Your inheritance is gone. You've commingled it, made it into a marital asset. If you want to not have it a marital asset, keep it as your inheritance. What does that mean? Keep it separate. Don't commingle it with marital assets. Don't take the money and buy a house and the house is in both names. You know, if once you start doing that, you water down your title to that property, to that asset, and it goes from being your inheritance to just marital property. Now, having said that, let me go back to what I was talking about before. There is a strong school of thought that supports the proposition that if you take money, let's say, and you put it in a separate interest-bearing account, your inheritance, not commingled with your spouse, the corpus of that money always remains yours. That's your inheritance. But there is a strong, supportable school of thought that the growth of that money, that is the interest that it accumulates, that might be considered a marital asset. So let's say you have $100,000, by the time you get divorced, it's grown to $107,000. The 100 is yours because you didn't commingle it, it's your inheritance. But that's 7. That extra growth, that occurred during the marriage, and that may be something to argue about, it may be subject to division. In that scenario, you'd end up with $103,500 and she'd end up with $3,500. That's how that would work. But again, that is something that's subject to negotiation. Your lawyer will certainly tell you in the totality of circumstances how the court might likely equitably divide that particular asset. If you have any questions about that, reach out and of course, we'll be glad to help you out.